We'll have a quick update from Andre Ong, my business partner here at Sharrock Pitman Legal and an accredited property law specialist. He's going to just share some news and changes affecting commercial leases that we think would be helpful to share while we're all together, so you're aware and on top of things. Thank you, Andre.
All right, thanks very much, Mitch. So I think we can flick through to the next slide. Thank you very much, Kristen. So basically, for those who don't know, the Retail Leases Amendment, I should say Retail Amendment, by the way, so Retail Leases Amendment Act 2020 reached royal assent on 23rd of September. That was mooted pretty much all through last year, changing some pretty fundamental things in terms of the way retail leases operate. I will, as briefly as I can, because there have been some pretty substantial changes, especially with the renewal of lease process. I'll go through it as briefly as possible, so we can obviously move on with Stephanie as well. So first thing with the essential safety measures costs. Previously, well, since 2015 in any event, it's been clear through an opinion released by VCAT that essential safety measures costs, basically being your fire safety costs incurred through premises and buildings, were landlord costs and couldn't be passed on to tenants for both commercial leases and retail leases. That's now been changed. So as of the 23rd of September, essential safety measures costs can again be claimed by a landlord from a tenant. Now, note that landlords can't, and that assumes that that's in the lease to be able to pass that on. Secondly, even if it has been in the lease all the way back since before 23rd of September this year, a landlord can't back claim the essential safety measures cost before that date. But that is a key change there to be aware of as an additional cost to be passed on to tenants. The disclosure statement process as part of entering into a new lease has also been updated. So now disclosure statements must be provided at least 14 days before the commencement date of a lease. Before it was 7. And before it was, there wasn't really a consequence if you happened to send the disclosure statement late, as long as it was served. This time around, the commencement date of a lease must be at least 14 days after the date the disclosure statement is issued. And obviously that causes a bit of a problem if disclosure statement information isn't provided ahead of time. You then have arguments about when the lease actually commenced. And also circumstances where a tenant may well want to go in a little bit earlier, whether that's to commence fit out or just commence trade as soon as possible. That's obviously a bit of an issue there that's not quite factored into the legislation. But there are different ways that people might be able to address that, whether that be fit out license periods or pre-lease commencement license periods to just work through what's actually commercially required, but just be aware that obviously this change has happened and it has a pretty fundamental effect in terms of working through what's your actual lease commencement date, and then consequently what are the dates for the end of a term, the date that you needed to be exercising options, that sort of thing. The next change is with security deposits. There is now a mandatory return date for them. So it's 30 days. Security deposits have to be returned within 30 days of the date the tenant actually meets all of their lease obligations. Before this, there was no real time limit. It was a reasonable time assessment. Now, the major changes I'll go through sort of all in one block. So there's been a change in terms of the renewal of lease process. The early rent review is part of that, and there's a cooling off period on exercise of option that's also been factored into that. So because of the complexity of the changes, what we have done is come up with a bit of a flowchart to actually run through how those changes operate. So yep, there we go. Now, that is probably a little bit small in format, as you might see, and quite complicated with all the different lines going across. That will be up on the School of Hard Knocks page for accessing after this, if you've all got your passwords and usernames. Alternatively, by all means, please feel free to email Kristen and we can activate those if you haven't got them. But basically, to summarize the key parts of all of this, the renewal of lease process now runs like this in terms of a retail lease. So a landlord has to give a tenant a reminder to exercise their option at least 3 months before the last date to exercise that option, as stated in the lease. Now, that notice has to include a variety of information as listed out in the middle block there of the middle white block there. The key piece of information that will be of interest to both landlords and tenants is that a landlord now has to state the rent that's going to be payable in the first 12 months of the renewed term. So that's fundamental change since before this point. An option had to be exercised by a tenant effectively in the blind, and the market rent review would then happen afterwards to assess what the market rent is. So the tenant, when they exercised their option, didn't actually know what they would be paying in the first year of a renewed term. This change means that they will be exercising their option fully aware of what the rent is going to be. Now, moving on from that, obviously, if the rent's agreed and the tenant's happy to exercise their option, then pretty much we run straight down that column on the left-hand side. There's an exercise of option, and you just go forward with the rent that's proposed, and new documents are prepared. If, however, that isn't agreed, and we are moving down the situation of, okay, we're not happy with that rent that's proposed, what do we do next? The tenant's got a couple of rights. They can pursue the early rent review process. So that basically is having that market review process that's factored into every lease pretty much earlier on. So rather than waiting until the actual market review date, which is normally specified as the first day of the new option term, the tenant gets to ask for that review to happen earlier. Now, they have to ask for that review 28 days after they've received that notice of reminder to renew their lease. If they do that in time, then they can work forward, try to negotiate a rent with the landlord. So it's a negotiation process first. But if you can't negotiate an agreement, so you get to that little red square that says rent not agreed, about 2/3 of the way down, then it goes through a specialist retail valuer appointed through the Victorian Small Business Commissioner, and rent's determined by valuation. If, on the other hand, obviously you negotiate the rent and you reach agreement, then yes, by all means proceed forward with having new documents prepared. Interesting situation arises if they don't exercise that right to have an early rent review in time. They've got 28 days to do that, as I said. If they don't do that in time, well, the rent that's proposed in that renewal notice is going to be the rent that's applied. I would put a little caveat there in terms of, I would suspect there will be some disputes relating to that in terms of exactly when the 28 days starts, when did the tenant receive the notice. So it's crucial from a landlord perspective to be making clear when you've actually served and when the tenant has actually got notice of that renewal notice, have a proper record of that. And obviously from the tenant's perspective as well, when did you actually receive it? When did you have notice of the rights that are set out in that renewal notice? That's going to be key, because that's going to be the start of the time frame for you to actually take issue with that rent. Jumping onto the cooling off rights. So these are new as well. So if a tenant happens to have exercised their option either before they got the they got the renewal notice at all, or before they've asked for an early rent review, if they've exercised their option in that situation, effectively having exercised it in the blind in terms of what the rent might be, or in the blind of a market rent review, as long as they have the right to still have that early rent review, then they can exercise a cooling off. Now, if they exercise the cooling off, it has to be within 14 days of the exercise of option. If they do that, then they do get to reverse their position in terms of backing out of the option exercise that they've just done. But in doing so, they've given up the option rights altogether. So it's a pretty serious thing then to exercise that cooling off right, because you've given up your options as a tenant. You end up in a position of trying to negotiate a new lease from scratch if you're trying to stay. So it's not something that would be done lightly, but the government, in their wisdom, has put in that right there to allow an escape hatch, basically, for a tenant if they want to reverse out of position and escape from the lease without being bound to continue with that option. So look, that's a really quick précis of the various changes that are operating. There's, I'm sure, questions that will flow from that, and by all means, feel free to email me after, and I can address those. I might just go through in just 1 minute a couple of quick things with respect to COVID. As you might know, COVID regulations for rent relief were amended on the 29th of September. So there's a second set of regulations that now apply, which required tenants to basically ask for the further rent relief to apply from October to December. That's very much more proportional to what they're directly proportional in terms of what their turnover loss actually has been. The key thing is the tenants are supposed to have submitted a further request for relief for that to apply. The other thing to be aware of is VCAT's just issued the first case where they have actually assessed the commercial tenancy relief scheme, so all the COVID protections that the government's issued out, which is a case called CB, Buffet and Deloitte. In that case, the tenant was actually in breach of the lease and hadn't paid rent through February and March, and were kicked out by the tenant before the protections came in April. But they were asking for relief and protection on the basis of those COVID protections that were put in April. Basically, VCAT found that they weren't entitled to those protections. The landlord was entitled to kick them out. If they wanted to get back into the premises, which VCAT was prepared to grant an order for relief against mortgage to let them back in, they actually had to pay all of the arrears of rent in full up to the point that they actually re-entered into the premises, not just in full up to the protection period when the COVID protections came in April, but all the way through. So just something to be aware of, that there's actually been a judgment now issued with respect to the COVID.